Good morning, Wills on Wednesday. We are talking about what happens if you pass away and you're married and you do not have a will. There are a lot of assumptions that husbands and wives make that your spouse, if something happens to you, will receive 100% of everything. And in fact, here in the state of Georgia, if you pass away and you are married and do not have a last will and testament, that is not necessarily true. So let me restate that. If you die and you're married and you do not have a will, your spouse may not receive everything as you assumed. In fact, here in the state of Georgia, if you pass away without a will and you are married, there are a particular set of rules that are going to apply to when you have to go through probate or your estate goes through probate. And that is what happens. People hear this word probate. And here in the state of Georgia, we have a separate court system, the probate court, separate judge, separate rules, even separate clerks and offices that you have to go to. So everything is separate. It's called the probate court. And so what happens if you are married and you die and you do not have a will that gives everything to your spouse, if that's what you want to have happen and if that's what you assume will happen, what may very well happen is your spouse may only receive 1/3 of what you own and what you have. And because the rules are almost like a fourth grade math problem, and I know that might sound somewhat casual to say, but it really is true. It's a series of about 6 statements that apply depending on who you are survived by when you die. So if my husband died, I have 2 children. Or actually, my husband has 2 children, right? Because it does not matter if those are children of our marriage. So if my husband had children from a previous relationship, those children and me as his wife all go into the bucket of people who are going to inherit from my husband if he dies without a will. So let's pretend that my husband has a child from a previous relationship, and then we get married, and then we have our 2 children. So my husband dies, and he has 3 children and myself. And so what ends up happening is this fourth grade math problem applies. I will receive 1/3 of my husband's estate, and then his 3 children, his previous child and my 2 children, receive equally the remaining 2/3 of his estate. So then that 2/3 gets broken down between the 3 children. So it is not true in the state of Georgia that the spouse will inherit everything from someone who passes away if they do not have a will, if they do not have an estate plan, that if that is what they desire to have happen, actually can put it in writing that that is what will happen. So if you are married and you assume that your spouse is going to inherit everything, then reach out to us. Let us help you get an estate plan in place. Let us help you get a will in place that makes sure that your wishes are carried out, that your spouse does in fact inherit if that's what you want to have happen, because here in the state of Georgia, if you pass away without a will, that may not necessarily be true. This is Wills on Wednesday. We're talking about spouses who pass away and do not have a will in place. Reach out to us at team@refecalaw, that's refecalaw.com, or give us a call at 770-508-6525. And we can have a complimentary consultation with you and your spouse. We can sit down and talk about just exactly what would happen if you passed away and don't have a will in place or don't have a valid will in place, or you'd like to get your will updated. Thank you for joining us. Wills on Wednesday, signing off.